Hey, Richard McClellan is on the other end of our line this morning, the super attorney from here in the state capital area. He's been in the courtroom only a number of times in his career, and every one of those times, as I understand it, Richard, at least the last I knew, was to argue in front of either the state Supreme Court or the United States Supreme Court, right? Welcome back to the program.
Good morning, Michael Patrick. Yeah, that's true. That's most of the type of cases that I've ended up having the opportunity to argue.
That's pretty darn good. You're like the Red Adair of law.
Yeah, I don't know about that. There's an awful lot of good lawyers out there. I've just sometimes got the right kind of controversial cases that end up in my lap. Not Roe v. Wade, though.
Speaking of controversial cases, yeah, you made the little transition for me there. It was 1973. And I'm just curious, you just give us a little bit of a history lesson, if you would, on what that meant in the United States and what the reaction was like at the time.
Well, here's an interesting thing. In Michigan, in 1972, the people voted on abortion, and they voted to not liberalize the law. Within a few months from the time of the election until the beginning of 1973, when the Supreme Court completely overturned the law. So to a certain degree, Michigan was unique in that it had the voters had dealt with the issue, and then 2 months later, the Supreme Court turned it over. But what this case has meant for the last 40 years is there's two very fundamental different worldviews. Women believe in the liberty that the Constitution guarantees means they can control their own body. There's another equally strong group of people who believe the most important thing is life, and that there is a personhood to this a growing person within them. And because of that completely different view, we have had 40 years of arguments in the courts and in society and in the legislature, and it is not going to stop because they are two fundamental important views: the ability of a woman to control her body, and secondly, when does life begin and what role does the state have to protect life? So it's not like it can ever be solved. It's fought over and over again on the margins. What kind of rules? Can we ban this type of procedure, like the so-called late-term abortion? Can we require more and more requirements on the facilities to make it harder to get one, create barriers to entry if you can't bury it? We also have huge regional differences in the country, and that's what Roe v. Wade interrupted, was a series of discussions in a lot of different states, some of which were coming down on one side and some on the other. So instead of state-by-state sort of evolution of the abortion issue, because it was clearly changing in the early 70s, we had the Supreme Court step in a pretty strong opinion, and they set the rule. There are even some pro-abortion justices who said it was a mistake for the court to have intervened and done that. But that's the kind of fight we've had for 40 years. So it goes on. I assume you have some others that have particular views on one side or the other. But if you stop and think, everybody who's going to talk about Roe v. Wade is going to come from one of these positions: either the liberty of the woman to control her body, or the liberty of the state to protect the life of this person that they believe. And and you're usually in one camp or another. There's very few issues where people are not. They end up on one camp or another, even if they understand and sympathize with the other side.
And it was 40 years ago today that Roe versus Wade decision was made. Aren't there some cases where if you, for instance, murder a pregnant woman, you get charged with 2 murders instead of 1, or there's additional penalty?
Sure, Michael Patrick. The law has never been absolute. The Supreme Court decision recognized that there are different stages of development based on the medical knowledge of the 70s, and they adopt this trimester. There are rules that say, in some states, not all, that at some stage in life, that person, that life is entitled to be protected. That doesn't mean that the woman can't, in controlling her own body, perhaps have an abortion. But it does mean that her boyfriend maybe can't beat her up and cause the death of that fetus that's growing inside her. So yes, you have. There's no absolute law. That's why it's a complicated area of the law, and it's going to continue to be because we have fundamental value differences and a complicated legal system that has to sort through all these human conditions that come along as how you, if the fetus is damaged, if somebody from the outside interferes. So is it a medical procedure require a doctor to be licensed? So many issues, and people will continue to fight over it today as they did 40 years ago, and we're fighting over it. It was a very big issue in the early 70s in the state of Michigan.
So just with 30 seconds left, do you feel this should be a state decision as opposed to a federal decision? Or
well, what Richard McClellan thinks, it probably doesn't make a lot of difference, but what I, maybe because I saw it develop, that there's some argument, and a lot of people argue that this is the kind of, because it's a fundamental difference, it should have been played out state by state, and you probably would have had more of a patchwork of laws depending on the politics and the people of a particular state. There's people on both sides that say, no, that's wrong. These are so important. We need a national standard, and that's what we've ended up with. But we do have quite big regional differences in terms of the states, in terms of their attitude toward this, and that will continue. So you're going to see some states pushing the limit, trying to get it. Other states have actually passed their state laws to guarantee the right of abortion, even if Roe v. Wade is overturned.
From the